All right. So a number of you have raised data retention, which you'd be aware has something of a controversial history here. And when it's been raised here in the past, the European directive is generally, the data retention directive from '06, has generally been pointed to as a model that we should be following. Now, you'd be aware that that has just been struck out by the EU Court of Justice. In part, they argued successfully that the rules were disproportionate, data retention this is, disproportionate and unnecessary to achieve the aim of ensuring data was available for the purposes of fighting serious crime. So does anybody want to reflect on that? Because you're obviously sailing into controversy if this is going to proceed here.
Thanks, Senator. I might begin. I am aware of the Court of Justice decision, and I think what's important is the basis of that decision. And there were about 4 key points that they reference, which my reading of does differentiate a little bit from the environment we have here in Australia. And I would argue that in a number of those cases, we either already mitigate some of the risks that were identified. For example, one of the bases that the Court of Justice identified was that there was no protection against the risk of abuse. So, from my perspective, our oversight regime, I think, does protect from the risk of abuse. So whilst aware of the Court of Justice decision, I would equally argue that our oversight regime, both from a legislative perspective and even a policy perspective, differentiates from what the European Union appears to have discovered in their Court of Justice decision.
All right. Anything else on that? Or that would be the main distinction, that in Europe they found that it would be open to abuse, and you don't think it would be here in Australia?
They also went on to talk about things like there are no objective criteria for differing retention periods. So there was a number of other things as well, Senator, which I don't address each year, but I'm more than happy to do a supplementary submission to you dealing with each of those issues in its own right, if you like.
The key distinction, I guess, that I'd make is the difference between being able to tell telcos, we've got a set of suspects here accused of something very serious, we want you to trap and store their material until we tell you to stop. That's targeted data retention, as opposed to indiscriminate for every person, man, woman and child in the country, retain their material for at least 2 years, just in case they turn out to be a terrorist. That's a very, very big difference, I guess. So you might be happy to address that now. Why not targeted, discriminate data retention for persons of interest?
Well, I think we'll all have something to say, Senator, but the reality is that we don't know the background to every crime that's either been committed or that is going to be committed. And
but on that logic, you wouldn't be installing surveillance cameras in every room of every person's house and tracking devices on all of us?
Well, no. Well, we wouldn't, because we're guided by people's involvement in serious and organised crime. That will eventually be a trigger that requires us to access particular data. We don't access blanket data. It is driven by intelligence or evidence that leads us in a particular direction.
Sorry, Deputy
Senator, if I may add, the opportunity we're seeking here is to be able to access data at a point in time over a defined period, and people are referring to 2 years or 5 years. The reality is law enforcement doesn't have access to that information. It's retained by the carriers and only provided to law enforcement at the time of us requesting it, based on information that comes to law enforcement's knowledge that suggests that material may assist in the enforcement of the criminal law and progress an investigation. So law enforcement per se will not have access to that material. It's retained by the carrier, and our request is that there is an obligation on carriers to retain that. So in the event that a crime is detected, or there is reasonable evidence to suggest a person may be involved in criminal activity, we can access data which is being retained. At this point in time, some of that data disappears in the space of 24 hours.
Most of it does.
Yes, and it puts us in a difficult position to progress some investigations, and there are anecdotal or case studies that would show the lost opportunities and also some of the advantages where we've been able to use that stored data when we've had access to it.
This might apply unevenly across each of you, so feel free to jump in, but the annual report, the TIA Act annual report from last year lists 319,000 telecommunications data requests, the bulk of them from state and territory agencies and a small minority from Commonwealth agencies. But it's impossible to tell, and I can only operate on the basis of assumption that that's not 319,000 people. There's a much smaller number of people who, and a very large number of requests for overlapping amounts of data. But when each of your agencies makes these requests, what limits get placed on how discriminate or indiscriminate those requests are? So could you ask for an entire township's telecommunications data, for example, if you thought that was justified?
Senator, the first hurdle we would have to get over would be the budgetary implications of doing a search like that with such a blanket parameter. I can speak on behalf of SAPOL. Our requests for data are quite targeted in terms of individuals, and that might be that one individual has several services that we're looking to access the data from. And it's usually in those preliminary stages of an investigation where we have information to suggest that person may be involved in some way. There is also the opportunity that accessing that data can demonstrate a person's non-involvement in the particular matter that's being investigated. From a South Australia Police perspective, an investigator is required to make an application to access data, which is determined by the officer in charge of our telecommunications interception section. So we have a senior officer who authorises that access based on our own thresholds to ensure that the access is appropriate in the circumstances.
So all of those 390, I won't ask you to speak for the others, but as far as you're concerned, you have each one of those requests is individually named?
Yes.
Okay, and how many degrees of separation out do you go? So if one person, in grabbing their material, they might implicate 50 others, just for the sake of argument. Does that then bring those 50, are you able to basically say this person and 2 degrees of separation out? Or I think that's what happens in the US.
If I understand you correctly, as a result of checking data on one particular person, we come up with others that are of interest to our investigation.
Yeah.
There would have to be the same scrutiny placed upon those people in terms of assessing their likely involvement or otherwise, and base our application for accessing the data on the intelligence we hold in relation to that person. It wouldn't simply be a case that because their name has come up in that list that we automatically access their data.
Okay, you have to go back and file a separate request.
Yes.
Across each of you, the paperwork that you need to fill out internally in order to get one of these things authorised, is that consistent, or does each agency, I think it was the AFP actually, the Commissioner gave us copies.
We have tabled our pro forma. I don't think it would be consistent, Chair.
Would not be
consistent, no.
So each agency develops these from the ground up?
Well, if I might assist, from ASIC's perspective, again, it's a little like the other agencies have mentioned. It actually comes back to your own legislation and what it permits you to do in terms of conducting an investigation and what processes you put in place to deal with that. In our case, if we're going to conduct an investigation, a delegated officer of the Commission has to evidence that there's reasonable grounds for suspecting a potential contravention of a law that ASIC administers or is responsible for enforcing. Yeah. We have delegations set out and processes internally for who can exercise those delegations or referral points, as the Deputy Commissioner referred to, within our agency. Again, it comes back to, if you like, the scope of the particular investigation, and budgetary considerations too, not just budgetary considerations, but really efficiency considerations, determine that you will, while you may start with a broad mind about what the potential where the investigation might lead you, it's very, very important to try to narrow down pretty quickly what you're actually looking for. And in our experience, while we do make a substantial number of these requests, in particular for metadata, less so for stored communications, but also for stored communications, which has proven essential to some investigations. For example, of the collapse of the Trio Capital Group, the largest superannuation fraud in Australia's history, that became a very refined request very quickly.
That was a warranted request, though, the stored communications request.
The stored communications was a warranted request, that's right. The metadata tends to be used in insider trading or market manipulation cases where you have a particular person who you may be interested in, and then to search whether there may be people who've traded or had access to particular information that you might be interested in.
Having looked at the submissions and heard the evidence so far, like in no way am I trying to undermine the value of this material to law enforcement or intelligence gathering. It's more that we have a very uneven or asymmetrical system that forces you to jump through very severe procedural hoops to get a warrant, to listen to my phone call or read my email, and a piece of paper that is authorised by an unknown number of people, by an unknown number of agencies actually, to get hold of material that I submit can be just as invasive if it's aggregated. If you've got enough of it, it can be just as invasive. And a number of you have already raised budget constraints, but is it not the case that there are fairly sophisticated tools out there that allow you to take this data and map it, you know, like large amounts of it, and map it according to who's talking to who? Is it really that much of an overhead to grab this material?
Senator,
and make sense of it?
I might just add, in terms of the data that we're talking about here, it's important to note how variable that data is. Some of it is very low level, and I certainly appreciate your point that collectively it can tell a story. But for example, subscriber information, a name and detail, very low level, through to a range of other information that might be considered high level. I suppose it would be difficult to presume that all of the information that falls into this category is the same type of information. Sure. And that's part of the complexity of what we're dealing with here. Some of it, if you were to impose strict oversight for the obtaining of very low-level information, would cause some real practical difficulties for law enforcement who are trying to maintain the pace of quite fast-moving organised crime investigations from time to time. And particularly in the case of state offences of homicide, for example, those investigations can move very quickly. And it's important to be able to, with appropriate safeguards, be able to access the information that we require quickly. In Queensland, similar to the other jurisdictions, it's a senior officer involved making that decision. And I'm not aware of any issues or concerns with regards to any of the previous accesses involving my department.
We would have no way of knowing, or this committee would certainly have no way of knowing if there have been issues, though. This all flies completely under the radar. And I think the conversation that we're having here is maybe differing definitions of appropriate oversight. That's all.
Chair, can I just add,
of
in
course,
terms of your question about cost, you know, we have the resources internally and software that's able to sort data and provide various filters and levels of analysis. But there is a significant cost impact on the jurisdictions simply to access the data, and that's, I think, predominantly the cost that we're talking about. It would be prohibitive for us to do the sweeping sorts of collection processes that I think you're referring to. There's just no...
The phone company sends you a bill?
Sorry?
Because the phone company sends you a bill?
Absolutely, yeah. It's supposed to be a no profit, no loss arrangement, but I think there are varying degrees of interpretation as to what that actually means, and we certainly do expend a significant amount of our budget on accessing stored comms.
How is this material aggregated with open source collection on people? Like, I would find it hard to believe that you're grabbing this material and then deleting it as soon as it's no longer needed. I mean, some of these cases run for years and years and years. You maintain databases of open source files on individuals and social networks. How is the material that you're then grabbing from these metadata requests plugged into that?
Unless anyone else wants to jump in, my understanding is whilst we have an open investigation, all of the material we can collect in relation to a person of interest, a subject of the investigation, is incorporated into an intelligence profile, including linkages with known associates. And you know, we would undertake inquiries or information collection processes in relation to associates as well. So that material would remain in our systems as a part of an active investigation and be completely integrated with any other material that we're able to source in relation to the people that we're investigating.
Okay, and then that portion of it that appears under the metadata request is deleted when it's no longer necessary. Is that always the case? Like you're obliged to destroy material that you get under warrant.
Yes.
Are you obliged to destroy the telecommunications data if it's not warranted?
I'd have to take that on notice. I'm not sure what our exact system is in terms of this data we're talking about.
Could I, unless anybody...
Chair, I don't think the Act doesn't require that of agencies. It requires it for content data.
Yeah.
And it's very clear what the regulations and requirements of agencies in terms of non-content data, metadata. It doesn't require that it be destroyed after a certain amount of time.
So it'll just come down to different agency policy then?
Different agencies, different systems of managing cases, different databases.
What about prospective metadata, where the threshold of access is much higher, and you've been referred to a couple of times this morning as the top end of town? So now it's not the RSPCA and local councils, it'll just be you guys, I suspect. Prospective metadata that allows you to map somebody's life as they're living it with, I guess, a small lag time. What are the threshold requirements for you applying and receiving that material, and does that need to be destroyed?
Chair, if I can, and certainly we'll put more on the record when we appear, but the thresholds, as I understand it, are the same, and the requirements are the same. This is a question of the amount of material that now is non-content and the way that people are using telecommunications data, less so than what the legislation is specifically saying we can or can't do with it. So, as I understand it, prospective material has the same authorisation and thresholds as other non-content data.
Okay, so I suspect the bar's a little bit higher inside the AFP, but I think it's section 5AB, you authorise or you delegate an officer
Yes.
to be able to
And for the AFP,
receive
that's a
these,
superintendent, yes?
Yeah, okay. And they would receive a request from an officer?
Correct.
They would, it's like a 4 or 5 page document from memory.
Yes.
They would make sure that that checks out. They'd file it. It gets submitted to the TIA Act annual reporting process quarterly, and
Yes.
then we see it once a year. And is there anything further, or is that it as far as process goes? Then that gets filed with the telco, and they provide the material.
So, Chair, and I don't wish to speak for other agencies, but from an AFP perspective, what we don't record is the number, and this has come up before in other hearings, what we don't record is the number of rejections, which I wish I was able to... Of rejections that a senior officer who'd received a request.
Okay.
I would like to be able to put on record the number of rejections because I understand anecdotally they are quite high, which would give the committee some comfort that there is a level of threshold that's appropriate. I don't have that, but once authorisation is approved, then it goes to the internet service provider, whoever the company is that has that material, and that material is then provided to the investigator.
Mm. Does this stuff touch, so I'm presuming it does, social networks, as well as we talk mostly about email and web traffic. The AG provided us with definitions that I understand you all work with, that a URL, a web address, or let's stick with that actually, the subject line of an email would be considered content, not communications or telecommunications data. Is that consistently upheld across everyone at the table?
From the AFP perspective, yes.
Yes,
No,
from
yeah,
South Australia.
okay. And then there's no further requirements to destroy that material. This is basically just building up over time. 200,000 one year, 300,000 another year.
We, in an ACC context, Senator, we have a fairly strict regime of constant review, which is documented and is in fact available to the Ombudsman as well. However, I'd just like to share, let me pick out more motorcycle gangs. They are an ongoing existence. An investigation into their criminality today does not mean that they're going to cease to exist tomorrow. And you can imagine that if we did an investigation into individual A today and charged that person and then all that information was destroyed, individual A is going to be committing offences the very next morning, more than likely. So you will begin the whole process again. So there are scenarios like that where it is in our interests, it is efficient, and it is a cost factor where that intelligence continues to be relevant to people continuing to commit organised crime.
Yeah. I guess what we're dealing with is everything, the spectrum from violent terrorism to that kind of organised crime that you're dealing with day to day, to somebody being bitten in a park by a dog. And the same regime appears to apply from end to end. So again, without trying to get underfoot of the very serious work that you're all doing, it still appears to me that there's a very large loophole that's opened up at the same time as these new categories of data have appeared, which kind of brings me back to the point where I started. If it had been possible to track someone's location around the landscape in 1979, my view is that you would need a warrant. You'd need a warrant to get it.
Chair, if I may make one point of clarification, I don't wish to mislead the committee. In terms of prospective data, there is an additional requirement that may go to the point that you just made about agencies and their use of the data. It does require that it be a serious offence or an offence with a punishment of 3-year imprisonment or more. Okay. So there is a slightly higher threshold that still our internal authorised officers have to consider for the prospective data. Getting to the point of watching somebody or tracking their movements.
It's a much higher threshold. There's no custodial penalty needing to be applied at all.
There is no, sorry?
There's no, so it's 7 years to tap a phone, 3 years for a stored communications warrant. Yes. You're saying 3 years, that is also the threshold of penalties for prospective metadata.
Prospective metadata, yes.
Still no warrant, but it does raise the bar.
Correct.
And restricts the number of agencies.
Yes. Well, it wouldn't restrict the agencies. It would restrict their ability to use it.
The AGD just told us that it did. So councils can't apply for a prospective.
Okay, I'll take advice on that, and yes, it does. I guess the point is it's not for the dog bite example that you give.
I'm not pro dog bites either.
Senator, just on the point you make though, I mean, the Act started in 79, I started in law enforcement in 82. And my recollection is that from the beginning in 1982, the subscriber details of who owns what phone was available then. And there was no intention that we would need to obtain a warrant, for example, to get the subscriber details of a fixed phone service, which we're basically dealing with, or a fax in those days. Yeah.
It's just that these things were, you know, the size of a paving slab in 1982 for those who had them at all. And I would put to you, I guess, that what we're dealing with is a single regime of two double-sided A4 bits of paper to receive something that's either that innocuous, as you're putting it, that shouldn't need a warrant, or real-time movements everywhere somebody goes, or a very dense map of their entire social network.
Well, Chair, if I might say, I don't think we've said that it's innocuous information. I think we believe that it is not innocuous, it is sensitive and it needs to be dealt with appropriately. And the Act, while in the AFP submission we do talk about requirement to some of the oversight mechanisms could be refined, absolutely. There are thresholds, and those thresholds are appropriate in terms of what level we need to reach internally, or if it's a warranted information before. So I don't think we're saying it's innocuous information.
Okay. No, I'm not intending to verbal you. All right, I'll leave it there unless other committee members have questions. Oh, yeah, go ahead, Mr Williams.
The prospective, just by way of demonstration, like the ATO does not have access to prospective information. We have only got access to historical data. So there would appear to be a levelling of that in the design, in the system in a sense anyway.
And ASIC?
I'll take it on notice, Senator, just to check. I think we certainly have the ability for an authorised officer to seek metadata. Then only stored communications are only on the basis of warrant, and we're not an interception agency. We don't have the capacity to seek a warrant for interceptions, although we made a case for changing that.
Could you just take on notice for us, if you're not sure now, whether you're able to access prospective telecommunications?
I will do that.
That'd be helpful.
Yep.
Go ahead.